Hello and welcome to Essentials for Planning and Zoning Board Staff. It's the last webinar we have scheduled for the season. That's not to say we won't schedule others later in the year, but we get pretty busy with our on-site training, and our schedule is coming together. So if you want to see us in person, check our website, the Department of State's website, under Training and Assistance, the Division of Local Government. It's and our website is at the end of this course, and you should all have received handouts. The website is on the last slide, or one of the last slides of the handout, so you can check that out. And you see our email address on the screen. You can email us if you need a link to that schedule. We organize most of our training through county and regional planning agencies, but then we do these webinars for people who need their training at the end of one year, and the new members, we target new members at the beginning of the next. So I imagine we have a lot of members of planning boards and zoning boards of appeals on this webinar, though it is targeted toward planning and zoning board staff and other municipal staff who assist with the work of the planning board and the zoning board of appeals. And so to do that, this course has a history. It was recommended, it was actually requested by one of our training providers. Oh, somebody said bad audio. How's everybody else hearing me? I'm gonna, there was a question.
You sound fine. I'm not sure.
Okay, good. Yeah, I had some audio disruption earlier, so I hope that resolves itself. But I just spotted somebody saying that that I wasn't that audible. So this course was requested by one of our hosts of a training event, and they said we need a course for staff about how to take minutes, and the course, we need some instructions on minute taking. And we built this course, and we only had a few slides on minutes, but then we realized that it really made a lot of sense to teach staff very general, and give staff very general information, the essentials for them to understand the functions of the boards to take more effective minutes. So it was built around the minutes, but the course is really just targeted toward municipal staff who assist with the planning board and the work of the planning board and the zoning board of appeals. And my name is Christopher Eastman, and I'm presenting today with my colleague James Bragg, who can unmute himself and say hi, and he'll take a few slides a little later on.
Good afternoon. Thank you for the introduction, Chris.
You're welcome, James. And Lindsay and Monica will be taking questions. They'll be responding to the question and answer. The questions in the question and answer function, which to turn on, you can hit the button at the top right of your screen to engage the questions, and you can type a question for answers from our staff. If you don't get an answer right away, it might mean that they're collecting your question for us all to discuss. So we'll do that later. We'll maybe stop at some point halfway through, and then at the end of the webinar, we'll discuss some questions as well. And then John Furtado is helping us with tech behind the scenes. Thank you, John, for all of what you do, and John is largely responsible for your certificates as well. So again, I'll emphasize for those who didn't hear it earlier, the certificates won't be coming until probably next week. And if you don't, if your question isn't answered, you can. Oh, this one doesn't belong. Sorry, this is for the LGE. If your question doesn't get answered, then you can email us at localgov@dos.ny.gov. And you can email us or call us at the phone number on our last slide at any time. You don't need this email address here, not this phone number, but the one at the end of the course, 518-473-3355. Anytime you have questions about planning, comprehensive planning, land use regulation, general local government procedure, or anything else related to local governments, you can give us a call. So we'll start. We'll get started. Enough with the introduction. The course, as I mentioned a few minutes ago, is targeted toward staff of planning boards and zoning boards of appeals, if you're so lucky to have them. And maybe you're in a smaller town or village, and it's somebody from the town or village clerk's office who assists with the planning board and the zoning board of appeals. But it's really it's ideal when those boards have staff. They're of course a lot of the time in many municipalities very part-time. And it's a challenge. And I was talking to a new town supervisor just a few weeks ago about the challenges of hiring the longtime board clerk. Left sometime in the last few months, and it's been very hard to find somebody to work part-time for the board. And so sometimes we have to get creative, and you can call us offline, and we can tell you about what we've heard out there of some other boards and municipalities, how they've managed to staff their boards. But there's a lot of work involved. It's in administering these boards, and it's a lot more than volunteers. It's enough to ask of volunteers to attend meetings and have to know. There's a lot to know about your jobs as volunteer or stipend receiving members of planning boards and zoning boards of appeals. And it just helps so much to have a knowledgeable and up-to-speed clerk or secretary. So because there's a lot that has to go on, and this photo, this graphic is supposed to be kind of funny, but there's truth to it. There's a lot of back and forth between applicants and communication among board members, between the municipal staff and board members, and the gatekeeper, as we call the person who's on the front line who receives the application. It goes a long way for that person to be able to speak to applicants and describe to them the process and make it a little less intimidating. And inevitably, the better that person is at his or her job, the more efficiently all the board's work will go, and the more effective your zoning regulations and your planning endeavors will be as a municipality and a larger community. So a lot of the time, if possible, it's a board clerk or secretary who receives the application, gives out the application, lets people know where they can find the application online or wherever, and then takes those applications in and makes sure they have the critical information, and passes them on to the board members to be sure they have all the information they need to be considered. Sometimes it's the board chair who does this work. I've spoken to local officials who said, oh yeah, our planning board chair was practically an employee of the municipality. He was there, he came in 4 days a week and had a mailbox there, had an inbox there, and there was regular communication between the board chair and the rest of the staff. A lot of the time it could be the enforcement official, but in many smaller municipalities, the enforcement official is only there a couple days a week. But that person is the logical recipient of applications and communicator with applicants. Larger municipalities have municipal planners. There are probably not many, percentage-wise, maybe 10–15% of local governments in New York, if that, have municipal planners. And it's interesting, I talked to somebody from a larger town a couple weeks ago, and he was saying that the planning staff really handles, they are the first line of review, even before the building department. Most municipalities, you go to the building department first, and maybe you have to go to the planning board for a site plan, or you end up in front of the ZBA for some relief. But this individual just described how it was the planning staff who were on the front line and took applications and funneled them to the building department, no matter what. They were the first line of review. They are the first line of review. And then, of course, the municipal clerk's office can assist with these matters. So these are, we surprisingly didn't even have information about the functions of the board. This is very in this course before we recently updated and enhanced it and improved it some. But this is really important for, obviously, board members, and we suspect that many of the attendees are board members, but also very important for staff to understand the functions of these boards, the kind of overview of the functions of the board, the broad functions, the broad perspective of what the planning board does and the distinction between it and the Zoning Board of Appeals. So the planning board functions as really primarily, although a lot of people forget it sometimes, to do planning and to advise the local governing board about the status of the comprehensive plan, when it needs updating, and sometimes when it needs, while it's being updated or drafted, the planning board is the board that oversees that work. And they also oversee, we tend to rely on the members of the planning board, or at least this is how statute is written, and a lot of people think of planning boards in this capacity to advise the local governing board on its regulations, its zoning regulations, its subdivision regulations, its site plan regulations, what can be improved about these regulations. Of course, the planning board is doing the work of reviewing a lot of these applications, so its members are most knowledgeable in where the flaws are. And of course, they can advise on budgets for engaging in planning activities or implementation being actually changing the law or taking on capital projects. And then, of course, there are the other plans, the local waterfront revitalization program, open space plans, farmland protection plans, scenic corridor plans, and so forth, economic development plans, as the case may be. And then there's the review, and this is what we can't forget about, because sometimes planning board members don't feel like they're doing a whole lot of planning. They're doing review of applications for subdivision, for site plan. Of course, subdivision is the division of parcels, the division of one larger parcel into smaller, multiple smaller parcels. Site plan review, which is proposed development of the site. Special use permits, which are issued when there is a proposal for a use that might not fit all that naturally with its surroundings and needs some review or stipulation in order to operate, conditions to go forward. And special use permits aren't just for development, but sometimes for use for special events. And then there are other possible authorizations that are given to the planning board, and they might The planning board might be the historic preservation, the historic review board, for example, or the architectural review board if your municipality has that level of regulation. The Zoning Board of Appeals, on the other hand, is only municipalities with zoning have a zoning Board of Appeals, but when you have zoning, you have to have a Zoning Board of Appeals. And the Zoning Board of Appeals is the board that is that hears appeals from aggrieved applicants who disagree with the interpretation or determination of the enforcement official. And the enforcement official is usually the person who enforces both the Uniform Fire Prevention and Building Code and the zoning. Some municipalities have separate individuals who enforce the code and the zoning. It would be two different people, but in a lot of municipalities, the enforcement official does both. Well, appeals for interpretations, if the enforcement official says, no, that is a bar, a proposed bar, not a restaurant, or a nightclub, and nightclubs aren't allowed in our neighborhood commercial district. They're only allowed downtown or in highway commercial. And the applicant says, no, this is primarily a restaurant, and I'll prove it to you, that person would go to the ZBA. And then, of course, the more popular, the more common appeal to the ZBA is for area variances and use variances for relief from the dimensional requirements of zoning or sometimes the use requirements. When the applicant goes to the ZBA for a use variance or an area variance, the applicant acknowledges is on the same page as the enforcement official, agrees with the enforcement official, but feels that there is some special situation that deems that qualifies that property for some relief for the proposal. And we say that the ZBA is quasi-judicial because it's almost like a court. The aggrieved applicants go to the ZBA instead of going to state Supreme Court. If the ZBA doesn't rule in their favor and they're still aggrieved, then they have the option of going further and going to state Supreme Court. So as we kind of said in the gatekeeper slide, the board clerk or secretary or planner or board assistant or whatever you call that person is the first contact that applicants might have with the municipality in the process of going through land use approvals. So that person provides forms, maybe not handing pieces of paper over, but can direct applicants to appropriate areas of the website, and you all know how that goes. Provide general information, kind of like what I just did for you in these last few slides. Access to regulations and studies. Why certain development is more desirable than others, and so maybe this contact will enable the applicant to get the project off on the right foot, to streamline review, to be more consistent with the goals of the comprehensive plan of the municipality. And maybe there are questions that have to be asked of other departments. James is going to talk about this a little bit in a few minutes. And so that kind of communication is very important. And so application packets to remind applicants, or maybe to tell applicants that they haven't completed everything they need to get in front of the Planning Board or the Zoning Board of Appeals. And then sometimes their checklists, municipalities have checklists so that you can be sure that you've included everything you needed to do. Additional duties for this target audience of ours, the people that we're talking to the municipal staff who support the work of the Planning Board and the Zoning Board of Appeals, keeping records. And we'll go into that later in the course. Sending out notices, this all comes, we're going to go into all of this in greater detail when we talk about hearings, meetings and hearings, the process of meetings and hearings. But also kind of the business end of fees, when there are fees that have to be paid, and then of course the making sure that the materials that are to be discussed, agendas and application materials, are posted to the municipal website, and copies, if that's not feasible in your municipality, that copies be available before the meeting and at the meeting for those interested in seeing the agenda and what is being reviewed by the administrative boards. Referrals, we'll get into that. That's really important, where you have to send information about applications, and then we'll get into voting and decisions, and of course minutes. And James, as I said, is going to talk about coordination with municipal departments. So I'll turn it over to James, and he'll talk a little bit to start about the record.
Thanks, Chris, for setting the stage. We're going to talk about the record. You know, materials in your record tell a story, and consequently, having a well-organized record pays dividends. And there's two good reasons to maintain and keep an well-organized record. First, it helps demonstrate that the board's actions are in compliance with all the statutory requirements, and this could help to defend against Article 78 proceeding. And second, and probably more importantly, it's for transparency and service to the public. A well-organized record ensures the public can see how and why a decision was made. What are some of the documents that need to be in the record? First, applications and supporting documentation. This includes seeker materials, the environmental assessment form, evidence of compliance with the open meetings law, and public hearings such as an affidavit of publication, minutes, testimony, your county report 239 review, findings, decisions of any conditions of approval, and the zoning permits determination of compliance from the zoning enforcement officer. Application materials, it's important to know what is required as specified in local regulations. It's essential to have a crystal clear process for intake of an application. Who determines if an application has sufficient materials? That could be anyone from the clerk or secretary of the board, zoning enforcement official, the municipal planner, board chair, or board by consensus. It's also important to establish who's going to be the point of contact between the board and the applicant, because communication is key. It's important to process the application, have enough time to process the application in a timely manner. You don't want to drag this out. However, you're going to need time to go over to ensure that the application is complete for a meeting. Also, it's helpful to incorporate digital copies where it can be utilized. Municipal coordination of applications can be helpful. Including other departments can provide a perspective and expertise that might not be on the board. For instance, like they can provide technical review with their specialized expertise, like an engineer can help with utilities, site grading, DPW could help with impacts on municipal infrastructure, fire, looking at emergency access. Also having other departments look at applications helps with early identification of issues. They can address problems before the application gets to the board. There's legal protections to ensure compliance with all local and state laws. Police and fire review can ensure that documentation that safety concerns were considered. It helps with informed decision making, with better decisions, having that written comments from your department heads. Having a clear line of communication with your applicant is important. Do they know what to bring to the meeting, what to expect at the meeting? It's important that the applicant understands the process. Some attorneys, design professionals, of course, will know, but if it's a small business owner or a community organization, they might find the process very intimidating. So it's very helpful to have checklists to keep them informed so they understand the process from start to finish. It's very helpful. And we have publications that include checklists that can be helpful for you and the applicant in our James Kuhn Technical Series. That we can provide if you email us, or they're also online on our website. Public hearings. There's a difference between a public hearing is different from a public meeting. A public hearing is intended for the purposes of reviewing a particular issue and subject to notice, and allows and is soliciting public review and comments. Whereas a public meeting is where matters are discussed and deliberated, where the public observes and listens. The board may allow public questions and answers, but that is where a public meeting is, in essence, where the public just observes and listens. A public meeting is subject to all the requirements of open meeting laws with both notice and access. And notice for a public meeting is different. It's not a publication. A notice for a public meeting is in regards to the public media. And who is the public? Who are the public? The public is anyone without regards to where they live or where they come from. So someone who's not a resident can participate in or attend a public meeting. In order to have a public meeting, there needs to be a quorum. A quorum is a majority of the full membership of the body. If you do not have a quorum, you cannot conduct business. For example, if there's 5 seats, you need 3 people to be present for there to establish a quorum. Boards may only discuss and deliberate matters at a meeting open to the public. Meeting notice requirements. It's important to provide time and date to media at least 1 week in advance. It's very helpful to have a media list to send out the agenda with all of the information for that meeting. Sometimes that media list will include additional members of the public, such as the IDA, Chamber of Commerce, or community associations. This meeting notice should provide time, location of the meeting. It should be posted in a conspicuous place in a public location for at least 72 hours. Some smaller towns and villages might not have space for a town or village hall, so this could be either in a post office, school, library. It should be posted on a website. And also for video conferencing, it should have the location and public location of where the public can view the meeting. And I'm going to hand this over back to Chris, and he's going to talk about remote participation.
Thanks, James. I'll wait until I have control of the screen before advancing. Here we go. Everybody can see this is a big question, and I'm just going to make it as simple as I possibly can. Before COVID, there was authorization. Actually, I should go in order. No, I'm going to go in order of before COVID. Start on the right, public locations. Before COVID, there was the ability in open meetings law for boards to participate by video conference as long as they could be seen, heard, and their remote location was open to the public. And this is still the case. that the remote location, so if everybody on your board were meeting in a remote location that's public, you wouldn't have to have this special law authorizing you to meet that way. It's part of open meetings law. But then we had COVID, and the in-person requirement of open meetings law was suspended, and boards started meeting in undisclosed locations, non-public locations, but people could log on and see entirely remote, entirely virtual meetings of their planning boards and zoning boards of appeals and other boards that were subject to open meetings law. So everybody said, okay, this should become somewhat permanent. And when that emergency suspension ended, there was an amendment to open meetings law, section 103A, that allowed, and we call it the extraordinary circumstances provision. It allows governing bodies it authorizes governing bodies to allow boards to meet with some virtual participation. So what a lot of people don't realize, and this causes many to lose interest in this option, is that a quorum of the board, in this case, is required at the public location. So if you have a meeting Monday and there's a snowstorm and nobody wants to go to the municipal building, you all want to meet remotely, that's not an option. There has to be a quorum at the meeting, and maybe the person who lives the farthest or up a really big hill that doesn't get plowed very well can be the person who is meeting under extraordinary circumstances in a non-public location. And so this isn't a very popular option. Not many local governments have taken advantage of it. And I think I'm going to leave it there. I could say more and I could give more examples because we do have questions about this. But if you have more questions, you can give us a call. Another relatively recent change to open meetings law is the requirement that records be disclosed before the meeting, at least 24 hours before, on the agency's website. So this is a lot of work for those municipalities that, it's a fair bit of work for those municipalities who have the capacity to do it. And then there are others that don't update their websites every other day. So there's the loading of all this information on the municipal website. The benefit to it, and I talked to our colleagues in the Committee on Open Government, and I said, this is a tall order. You're asking a lot of local governments here. And their argument was that it was that the other side of it, there's all this work, but then the other side is it should reduce the number of requests for Freedom of Information law filings, requests for disclosure of records under the Freedom of Information law, because the records are all out there before the meeting. And so I hope that's been the case. But it's certainly the agenda and the applications enable the local official, enable the public to be somewhat engaged, to be more engaged with the business at hand. And I was at a meeting recently. I went to a public meeting, and it was a board that I used to serve on. And I was really kind of glad I wanted to go to talk to the board and just in general interest. And I was kind of glad at some of the items on the agenda. I hadn't looked it up. And then I realized maybe I should have tried. But there were agendas at the meeting. And I was interested. I felt like I'd kind of lucked out because there were some really interesting applications on the agenda. Of course, I didn't get to talk to the board because the meeting went too long and I had to leave. But this is why this requirement is in place. So ideally, it would be on the municipal website, as you can see on, from the top and bottom points on this slide. We get a lot of questions about workshops and site visits. Workshops, when I was a municipal planner, we would have a workshop and kind of not even an agenda setting session, but we meet briefly before the official meeting to make sure all the members understood what was on the agenda, what was being applied for. And and this was an opportunity for everybody to just ask questions about the members ask very general questions without engagement of the public. The public could be there because it was a quorum of the board talking about public interest, public business, but it was not to deliberate. The deliberation took place. The work session was at 5:30. The official meeting was at 6. And later on, at some point in the meeting, the public would be given the chance to speak and ask questions. But this is just an opportunity for everybody to understand what's being applied for so that the meeting can go more smoothly. And the site visit, of course, is to go and look at the land, go and be on site in person and see what's being applied for and imagine how it could be. And if the whole board is gathering as at least a quorum, and of course a quorum is the majority of a fully constituted board and the minimum number of board members required for there to be business to act on applications. If the quorum of the board is gathered on site and they're planning on discussing the merits of the application, that site visit should be considered an open meeting. There are lots of reasons why you wouldn't want to do that, because not every property owner wants a bunch of the public walking around their property, their liability issues, and it's just, there are lots of reasons why you don't want everybody showing up to the site. And so the way around that is, for the easy way, is for members to visit the site individually or in small groups, in groups of less than a quorum, or if there's value in their going all together, and this came out of this case that you see on the bottom, Riverkeeper versus the Planning Board of the Town of Somers, and there's a little bit of case history associated with it. The board can go and only observe and take in information and not deliberate, certainly, and when they come back to the open meeting, explain, tell everybody what they were up to on site, and say that they all observed together but didn't deliberate, and that's what the open meeting is for. So when they convene at their next public meeting. So when I was on a board, I was just thinking about this recently. In our last webinar, I've probably only visited a site with one of the other members one time to meet with an applicant. Other times I would go by myself. It just worked out that way. So I have a message from my colleagues who are taking questions that there's some questions about the remote participation slide, and we should pause and take a few of those. So let's have them.
Yeah. Hi, Chris. Thank you for pausing. So a few people are asking about if there is a quorum at the town hall or village hall, what about if one board member joins remotely? What is that? Are they considered a participating board member?
Yes. That would be, and I'm glad you asked the question, Lindsay, and in public. Yeah, the person who wrote it in, don't go away, because I'll try to answer, and then if I didn't answer the full question, you can prompt me for more. But I might have been kind of quick about this. If there is, as long as there's a quorum on site and the board has, the governing board, so your town board, village board, city council, has authorized, has said, under extraordinary circumstances, one member can, or two members, as long as there's a quorum on site, members can participate remotely in non-public locations. And so you might have somebody who's sick, or somebody who can't get to the meeting because of weather, or somebody who's even traveling and away, who's participated in other meetings and and whose input is valuable. That the adoption of that extraordinary circumstances provision, as long as there is a quorum of the board on site, if you have that provision, then one or in some cases 2 members could participate remotely. So did I answer that question, Lindsay?
Yes, and then I would just add that that also just has to be adopted into your local law.
Yes. Thank you.
You're welcome, but great answer. Thank you. There were a couple others. I apologize. I'm just navigating back and forth between muting myself and the questions. But
yeah, if you want to discuss a few of the others, we can do that too. Take a couple now, and then we'll stop later and take a few more.
Okay, can you, one more, can you talk about what has to be posted to the website in terms of application components? And then we'll let you move on after that.
Sure. Thank you. Yes, applications, the agenda, obviously, and when this law passed, I thought, well, I want to see I don't necessarily have to see an application. I want to see an agenda, and I think in the language, it doesn't actually say agenda in open meetings law, and I discussed this with one of our colleagues in the Committee on Open Government, and she said it's implied that it's the agenda. And of course, you want to see when a project you want to see the project that you're interested on the agenda, and seeing the application materials, all the better. You don't necessarily, you can redact the personal information, name and address of the owner and phone number of the owner, or any other private information that you don't want everybody to see. But it's a public process, so people are going to learn something about the applicant. But it's the applications is the short answer, Lindsay. James, did you have anything to add to any of this?
No, that was actually pretty crystal clear, Chris.
Okay, good. Thank you. Okay, well, moving on from site visits and workshops, the typical order of business for meeting is taking a look at previous meeting minutes and maybe amending them and correcting them and approving them. And it isn't required that boards approve their minutes, but most seem to. And then usually it's old business first, consideration of applications that have already been discussed, and maybe new information is needed for them, and the applicant had to go and make some adjustments to what was being requested. And then consideration of new applications. Sometimes, and this actually happened at the last meeting I attended, there was discussion of a special meeting because just because of the timing of the way the application came to the board, they didn't want to hold it up, but they didn't want to wait another whole month, so they decided to consider having a special meeting. So setting that special meeting and setting a preliminary agenda for the next meeting, which is aspirational because applications come in between meetings, so you can't really, you might set the agenda for the items that you have to continue discussing, and then you adjourn, and that's fairly typical. This is regular board members are going to say to themselves, why are they talking about this? We know that, but new staff members don't necessarily, and it's really important for them, the target audience of this course, to hear why certain things happen the way they do. Sometimes when you're learning by doing, you don't really get to know the reasons things are done a certain way. It's just because they've always been done that way. So the distinction between hearing notices and meeting notices, of course, James talked about hearings versus meetings. Hearings are for the public to be heard. There are a few stipulations, there are a few requirements for people for public hearings, to notice a public hearing. And one of them is to notice it in the official newspaper, to publish a a notice, a hearing notice in the official newspaper. And we lament the decline. It's really tragic and heartbreaking, and I wish I knew what to do to reverse this trend. The disappearance of a lot of local newspapers and the lessening of their being in print. This used to be obvious and not that easy, not that big a deal. It used to be pretty straightforward. But then, as newspapers have stopped printing, finding the official paper has become more of a challenge. But this is still a law. It's still required. And if you think that it makes more sense to notice public hearings on your municipal website, well, that's required too. And if you want to send it on social media and you want to send it to neighbors, that's up to you, or to as a listserv by email. That's okay. You can go over and above. And of course, the general theme of open meetings law and hearing notices is the more you notice, the more effective your notice, the more in keeping with the law you are working. And so if you go, the hearing notice is required, and notice in the mail, there are certain notices that have to be mailed by the municipality, as you see on the screen, to the applicant and to certain commissions. And we'll talk about General Municipal Law 239M and N in later slides. That's county referral. But to neighbors, and we'll talk about this in the next slide, to notices to neighbors, that's a local law. State statute requires the hearing notice in the official newspaper, but not to neighbors. A lot of local laws require mailings to neighbors, and that's a local requirement. And it's not. If you like it, that's great, and you have to. If it's your law, you have to adhere to it. But if you want to repeal it, then you can talk to your local governing board about repealing the requirement that notices of public hearings have to be sent to neighbors within 500 feet of the applicant property. And then, of course, the sign on the property is one of those best practices that we can discuss. When there's a sign on the property, everybody knows that it's subject to a public hearing, and you can read what the application is on that public notice, either maybe not ideally nailed to a tree like this, but let's hope it's tied to the tree, or a sign on a stake in the ground, for example, or a sign in the window of a building. So, and then again, municipal listserv and social media are your choice. You can add those in addition. You can write them into your local law or not. Just do it because you think it's a good idea to notice your public hearings on social media. So we'll turn the page to Seeker, and I'll do these few slides, and then James can talk about referrals. But the easiest way to understand the Seeker process, and this is the slide that really made me understand it when I struggled with it years ago. You will receive an application, and the first thing you do, and this is really directed to agency staff, to the board staff, if the board staff can help classify the action, determine whether, or classify, I'll stick to the vocabulary here, classify whether the action is type 1, type 2, or unlisted, that'll really get the application started off on the right foot. That'll jumpstart the review, the efficiency of the review. And I should have gone in the other order in talking about the options for classifying the action. Type 2 means no review. Type 2 actions are categorically determined not to have a significant adverse impact on the environment. So if you note in your record that the action was type 2 in nature, you can just move on and not have to worry about the environmental assessment form. But if it is not on the type 2 list, and these are all in the seeker regulations, and we can help you find them if you have any trouble accessing them. This is a tip for members, for staff. Have a copy of the seeker regulations at your disposal, either be able to find them easily online or a bookmark or have a printed copy of them. For years, I think I still have a printed copy of them, even though they've changed since my printed copy, since I acquired my printed copy. But it's 80% accurate, even though it's several years old. I go online most of the time now to check for classification of actions, the type 2 and type 1 lists. So then you classify, you establish the lead agency. The lead agency is usually the agency with the most jurisdiction over the project. So if it's rezoning, it's usually the local governing board, your town board, village board of trustees, or city council. If it's the adoption of the comprehensive plan, same thing, because they are the ones with the power to do that. But if it's review of a subdivision or a site plan, then it's the planning board usually. The planning board is much more often the lead agency than, for example, the zoning board of appeals, which is more often if there's relief needed under the review of a project in the context of a larger review, the zoning board of appeals might be an involved agency. Then is the all-important significance, determination of significance, and that is POSDEC or NEGDEC. NEGDEC means there is no significant adverse impact to the environment that's been identified. POSDEC means we need some more information. And if you consider seeker an information gathering process, you'll find it a little easier. It's not the end all. It's not as strong as your local regulations, and in fact, it's triggered when you have local regulations to use. So seeker is just the need to consider the environment, a requirement to consider the environment at the earliest possible time. So if it is a positive declaration, that more information comes in the form of an environmental impact statement. And then after you have all of that, then you evaluate, the lead agency evaluates the implications that have been outlined in the environmental impact statement of going with different options, and then they make findings and go forward to the local review, the review of the site plan, subdivision, special use permit, or rezoning, as the case may be. So that is the easy, and I went into detail here, but because it's not the full course. But if you go back to this slide, if you struggle with seeker, go back to this slide and go through it again, because it really, to me, it's easier than the flow chart. That list is simpler but if you look at this one, you'll see that type 2 actions, you just identify that it's type 2 and it's the end of the seeker process. Unlisted and type 1 are really pretty similar. The type 1 action requires the full environmental assessment form and coordinated review among involved agencies. Involved agencies are those that have jurisdiction, they have say over the project. They're not just providing information, but the project will go before them for them to approve or deny or approve with some modification. So the ZBA or maybe the state DOT, potentially the health department, and then when you get to the determination of significance, it's really the same. The type 1 action carries more weight. A lot of people think, oh, because it's type 1, it's probably going to need going to get a POS deck and it's going to need an environmental impact statement. Not necessarily, and that's to be discussed. We discussed that in the full seeker course. So if you have questions about that, you can let us know, and we'll set you up, and you can learn more about seeker. But this is for staff members, and just we're going through it quickly in this course. Staff members should definitely try the EAF Mapper on the DEC's website. You can just search EAF Mapper NYS DEC. It'll come up. Do a pretend project, or a real project for that matter. Go through it. I think since this has been introduced, it's been out there about 10 years. Board, there's a lot of valuable information here, and board should be board members some might be familiar with it, but staff, if staff can use the mapper and gather the information for the board, you might have a board member who's particularly interested in doing this for your review of Part 2 of the EAF. Part 1 is the responsibility of the applicant. It's part of the application. And then the lead agency does Parts 2 and 3. Part 2 is the asking of questions about seeker, and Part 3 is the determination of significance and evaluation of the responses in Part 2 of the EAF. But the more familiar staff and board members are with the mapper, you have to turn off the pop-up blocker for it to work. But you can draw around the project site or select the tax parcel for the databases to churn out for you what sensitive areas might be on site or nearby. So it's a really good, it's a very valuable tool, and we encourage everybody to try it out. So distribution, filing, and publishing for seeker. This is something also very important. Board members should know about it, but it's really important for staff to know about. The Part 1 of the EAF, that's the application. That goes to the county planning agency with the application. You only have to send Part 1, not your determination of significance, to the county planning agency. And then involved agencies when it's a type 1 action. You'd send Part 1 of the EAF. And you should if it's an unlisted action. And then you should incorporate the negative declaration, if that's what the determination of significance is, into subsequent legal notices. When you see the word file, that means to provide a copy of whatever it is. In this case, it's the positive declaration, the condition negative declaration, the negative declaration. It's required for type 1s only. The environmental impact statement, notice of completion of the environmental impact statement, and notice of the hearing and when you have your findings. Send that to all involved agencies. It's important to know filing means to provide copy, to communicate that to the involved agencies. And then you should publish in the environmental notice bulletin. There's a little more on the ENB in the next slide. The positive declaration, any positive declaration, any condition negative declaration, negative declarations for type 1 actions, those actions that you won't see very often, but when you'll almost know it when you see it. Type 1 actions, when they're in that deck, they have to be published in the environmental notice bulletin. And if you have an environmental impact statement, the notice of completion. For a lot of people, this is going to be like another language. All of this seeker thrown at you, this is just but these are important slides to refer to if you find yourself confused by seeker, and we can help you out. And there might be knowledgeable people in your municipality who can help you out as well, but we're there if you need us. So the Environmental Notice Bulletin is the official online publication of the DEC, and the for type 1 actions, again, these are pretty rare for the most part. You'll publish both negative and positive declarations. For unlisted actions, only conditional neg decs and positive declarations. So if it's a negative declaration for unlisted actions, which there will be many of, you don't have to publish it. And for both type 1 and unlisted, in those instances where there's a positive declaration and you have an environmental impact statement, you need to publish notice of completion of the EIS. And you can see when it's published. I'm not going to get into that now. Where to find the ENB, the submission form, and other information is obviously there. We don't have to belabor that. So James, referrals, back to you.
Great skinny on seeker. Seeker can be very intimidating for a lot of people, so that was great, Chris.
Thank
For
you.
referrals, it's important to follow the procedure requirements of 239M and 239NN. Failure to do so, to refer an action, may invalidate a municipal action. So what is 239? So 239, what triggers 239 is a special use permit, site plan review, use variance, some area variances that are within 500 feet of a municipal boundary, 500 feet within a right-of-way of a state or county-owned road, 500 feet within the right-of-way of a county-owned stream or drainage channel, 500 feet within a state or county park, 500 feet within land on which a state or county building is located, and also 500 feet within a farm operation in a state ag district. Subdivision review, that could be triggered by 239N. However, that goes county by county. Some counties don't require review of subdivision. And there's certain exceptions to 239M. And think of it, 239M is in mandatory. Area variances within 500 feet of a farm operation do not have to be sent to the county. And also there can be a municipal memorandum of understanding between the municipality and the county to exempt certain actions or exempt certain locations. And generally, this happens with cities because the county and the city are working with economic development. So the county's already involved with that action. So there can be exceptions where you do not have to send out for county review. It's important to have maps to illustrate where these boundaries are. Your county planning department can help with that. And something that's really important, when in doubt, send it out. I worked with a town, and I was a county planner. I worked with a town planning board chair, and she didn't realize a certain road was a town road. It was a small, it was probably only about 1,000 feet. Had we had a map, she would have known, she wouldn't have missed that. So it's really important to work and have a map of the areas that trigger 239M review. And also it's important to note, referral needs to be sent to the county, and your board cannot act until you get the referral back. You can't act in advance of the county. You can't act in contingent on the county planning board. You let the county planning board make the rendered decision and hand that back to you. What are some of the documents that needs to go to the county? The county needs enough information to evaluate countywide impact. In essence, it's important to give more, not less. So what are the documents? Usually you're going to have a county referral form, you're going to have your seeker Part 1 environmental assessment form, a set of plans, if applicable. For variance is a copy of the code for which relief is being requested. For zoning, text amendments, and local law amendments, copies of both the existing and the proposed changes, copies of any local meeting minutes, and any other documentation submitted to the municipality as part of the application process. When you do finally get the county referral and your board acts, a final action report must be sent back to the county, once that your decision has been made. 239NN, think of 239NN as a nice neighbor. It's to encourage a coordination of land use regulation and development amongst adjacent municipalities. It's a notice. So you're going to refer a notice for any subdivision, site plan, special use permit, or use variances that are within 100 feet of a municipal boundary, and you're going to let that adjacent sister community know within 10 days prior to hearing. The notice can be either electronic or mailed, and it's addressed to the clerk, the town, village, or city clerk. And what should be in that notice? A description of the proposed action, location of the property, date, time, and place of the hearing, and how to obtain more information. And something that's also helpful, particularly for sending notice to smaller towns. Email is very advantageous. It's quick. You're creating a record to show that you are, fulfilling the procedural requirement of 239NN. And the town clerks get a lot of emails. You're getting everything from garbage complaints to how to license a dog. So I've always found it's very advantageous in the title of the email to put 239NN. What action is it? Subdivision? Is it a site plan review? And the address. If you just put the address, sometimes they might erroneously think, because it's so close to the municipal boundary, that they're trying to request a site plan for that adjacent town. So just keep it nice and clear for your town clerk. An ag data statement. So an ag data statement is supposed to provide local review boards with additional materials for possibly evaluating adverse impacts of a project on a farm operation. So any subdivision, site plan, special use permit, use variances that's within 500 feet of a farm operation in an ag district needs to fill out an ag data statement. What's in an ag data statement? It's going to be information on the applicant, a description or summary of the project, a location and SBL number, the owners of where the farm operation is located, and a map showing the project and farm operation. And this notice is also sent to the owner record of the farm operation. This is on the right here is a copy, a generic copy of an ag data statement. Sometimes, again, this can sound a little more intimidating than it is. However, again, the purpose and intent of an ag data statement is to evaluate what possible adverse impacts a project may have on a farm operation within 500 feet of that proposed project. And I'm going to turn the ball over to Chris, and he's going to talk about
Okay, thanks, James. I'm seeing questions flying in, and I noticed a couple comments about the outdated website for the Environmental Notice Bulletin. I hadn't realized that. Thank you, everybody, for everybody who pointed that out for finding that.
Oh no.
yeah. It's we probably have it in a couple of our courses. And I personally never use, and maybe sometimes I avoid putting websites up. And it just seems like the state for about 20 years didn't change its website, maybe not quite that long. There were no changes, like those links were solid and they didn't change them. And then they started changing a bunch of them. So it really throws people off when they bookmark those websites and keep those websites. But of course, they were the people who wrote in. I think were both able to find them, the ones that I saw anyway. And that's why I always say, just go into a search engine and look for EAF map or DEC, and it'll come up. But thank you for pointing those out. We'll update the slide or take the link out altogether. So voting, really important, obviously, for board members to know, but staff too, so you know how all of this works. There was a question I noticed about the 30 days that the board has to, or that the county planning agency has to respond to the full statement. And if 30 days have elapsed and it's been more than 2 days, if the county planning agency does send it in after 30 days, but the local board hasn't met yet, as long as it's received more than 2 days prior to the meeting, the board has to consider the county's referral. So most of the time you want to, and I feel like if the county really doesn't get back to you and 30 days have elapsed and you don't have anything, then you can move forward. It's back in your jurisdiction to move forward on. But and this is an advantage to having not a county planning board, but just the county planning. When the county planning agency is the staff, they can usually respond a lot more quickly than if there's a county planning board that has to meet and vote and so forth. So and to act contrary to when the county recommends denial or approval with some modification, and this could be to your proposed zoning change. Maybe the county planning board feels that, or the county planning agency, I should say, to cover all, the county planning agency has determined that there is an intermunicipal and countywide impact. There would be an intermunicipal and countywide impact to the change that would not be for the better of the neighboring municipalities and the county as a whole. To override that recommendation requires a majority plus one or supermajority vote of the local entity, the local board, and then an explanation of the reasons for overriding the county's recommendation. If a member misses a meeting and, maybe even the presentation, a public hearing, or the presentation by the applicant, that member is not necessarily precluded from voting, but should familiarize oneself with the record and the application itself, everything that happened, and if that member can sufficiently come up to speed and explain the degree to which that member who missed important components of the application process, maybe there was an initial presentation, a public hearing, and then it's up for a vote, and that member is the person who makes the quorum. You want that member to vote, and as long as that member has familiarized him or herself with the record and said so on the record, that member is not precluded from voting. So that's how to do it if a member misses a meeting and still wants to vote. In its appellate jurisdiction, this is the Zoning Board of Appeals voting on interpretations or variances. If the motion or resolution will only pass with a majority of the fully constituted board, a majority of the membership of the fully constituted board. So if it's a 5-member board and there are only 3 members at the meeting, and James is appealing for an area variance for the addition that he wants to put on his house, and 2 members approve it, but 1 denies it, it's denied because 2 is not a majority of the fully constituted board. But so it's a denial if it's never voted on again. But if at the next meeting within 62 days of the close of the public hearing, the other 2 members are present at the meeting and somebody says, hey, let's vote on this again, and it's not clear what the exact process is. Statute doesn't lay out the process for voting on the application again, so it's whatever process is deemed appropriate in the eyes of the Zoning Board of Appeals in your municipality. A member can bring it up. James can come back to the meeting and say, hey, do you want to vote on that again? I think the board would have to agree to vote on it, but the application could be considered again, and maybe it's just that 1 member who denied it before who denies it again, and all 4 other members approve the relief. They vote to grant the relief to James, and so it's not the denial, the default denial is reversed. But if you can't get a majority vote, then it's a default denial. If you can't get a majority vote and are never able to do it again, the appeal is denied. In its original jurisdiction, so if it's the ZBA voting on a special use permit, or the planning board, which doesn't hear appeals, the planning board votes for, or in original jurisdiction, that's what a new application, that's original jurisdiction is a new application, not an appeal. A site plan, special use permit, or subdivision by the planning board, the failure to have a majority vote of the fully constituted board is just no action. It's as if the board has never voted. So it's not a default denial, but it just hasn't. It's like it hasn't happened. And so you have the opportunity to try again, and it's really in the best interest of the board. We're hearing a couple stories around about boards just coming, just not agreeing, and they're not able to reach an agreement on an approval or a denial, and things just keep being delayed, and that's not good. This is what deliberation is for, to come to some kind of compromise. Remember, it's only for subdivisions that if you fail to have a public hearing within 62 days of the close, 62 days of the receipt of a complete application. When you have a complete application, you have to have a public hearing within 62 days, and within 62 days of the close of the public hearing, you have to make a decision for subdivisions. And if you fail to do that, it's a default approval. Again, only for subdivisions. The 62-day deadline exists elsewhere for just about all the reviews, really for all of them. The 62-day deadline is there. Make a decision within 62 days of the close of the public hearing. But for subdivision is the only one that has the automatic consequence to not having a vote, for not making a decision. Okay, back to you, James.
Thank you, Chris. We're going to talk about minutes, and minutes are important because they are the legal record of what was decided. And how are they helpful? They're helpful because in an Article 78 proceeding, minutes will be reviewed. Again, minutes are important for transparency for the public, and also they serve as the institutional memory. You know, they provide what was actually approved by your board. The minutes under Public Officer Law, Article 7, Section 106, mandates that every public body must keep minutes of all open meetings, The minutes serve as the official record of action, and the public must have access to these minutes. They need to be available at all reasonable times and places. If you should by chance have to have an executive session, and in my 15 years of planning for planning boards, ZBA, and historic preservation commissions, I never had an opportunity to go into executive session. But if you do go into executive session, the minutes are to be a summary of the final determination, and you're not to include information. There's 8 categories. Information exempted by federal and state law, unwarranted invasion of personal privacy, third, harm that might impair a collective bargaining process, 4, might impair or hinder law enforcement investigation, 5, information regarding trade secrets or confidential information that might cause injury, 6, info that would create danger to life or safety, 7, intra-agency materials, or 8, exam questions. But in essence, the purpose and intent is to keep really good minutes. They serve as your official record. You know, what should be recorded? You're going to have to record the date, time, place of meeting, membership, who is present, and who is absent. I'd also note special guests that are there. Also, it should be a general summary of matters discussed. You're going to record all actions taken, including votes. You should engage in roll call votes. Roll call votes should be taken so the individual members' votes are noted. Minutes are helpful because, again, they inform those not present what happened at the meeting. It helps absent members get acclimated to meetings of the past, and also gives future board members a sense of how a board operates. Who takes minutes? That's usually a secretary or clerk. It is not recommended for anyone on the board, and it's definitely not recommended for the chair to take minutes. They should be engaging in the deliberation and discussion of a matter. Taking minutes is quite a distraction. Minutes must be concise and coherent. Again, they're a summary. They're the permanent record of that meeting. Consequently, sometimes there will be corrections and amendments that are done. Usually they're done at subsequent meetings, and changes and corrections become part of the permanent record. What are some of the common contents of minutes? Again, board name, date, time, place of meeting, list of members in attendance, time meetings called to order and adjourned, date and notice provided to media and the public, approval and or corrections of previous meetings, previous minutes, summary reports and announcements, results of vote, and summary discussions, proposals, resolutions, motions. And now Chris is going to go more into the detail of the minutes, what should be taken for minute taking.
Thanks, James. It's just a few more slides here for me, and then James is going to be wrapping up. The open meetings law really for minutes does not require a whole lot. It's just the record of motions, resolutions, and votes. That's the minimum, and it really is minimum, and it's not all that helpful. It's what's required of open meetings law, but for you, and I think I don't want to belabor the point. I think James already said this, but the minutes are really the record of the board's actions, and they tell an important story of what happened at your meetings. So you don't just want the bare minimum. Of course, transcription of your remote meetings is required. This is a really important point. When you have those remote meetings, they don't come without a little bit of extra work. So you need a transcription of those remote meetings. And really the the reason we emphasize the value of meetings is so that you're able to look at the minutes and know, you being board members who voted and want to refer back to your actions, future board members, it's a historical document who look back at what you did, and very importantly, the enforcement official, because your conditions, the conditions that are attached to the approval are often in the minutes. You might have a separate decision document, but your minutes might be the only decision, the only evidence, the only text of that decision. And I'm just noticing, of course, we're running a little short on time. This was a shorter webinar, and so we'll understand if people have to leave, but we're wrapping up here, and anybody who stays later will get the extra time, of course. What we recommend is there's a happy medium of a summary of the discussions and the information that was presented, not necessarily as it was presented. Transcripts have their downside, that sometimes they're hard to read. Like if you read exactly how a meeting goes and how arguments go back and forth, there's a lot of stuff that you have to get through. But if the minute taker is really good at telling the story and editing out the redundancy, your minutes can be a really valuable and efficient way to get for members who missed a meeting to get up to speed, for example. And then a longer report it's good to have the information, but sometimes if it's pages and pages long, it could become burdensome for somebody to really read quickly. But if the information's there are advantages to the middle ground and the full account, of course. So use consistent headings so that you know where to look for the important information. The minutes should be organized according to the agenda. Again, record the information as the conversations would take place logically. Sometimes points get put off and then they come back and you circle around. It should be that discussion should be consolidated, and you should have, everybody makes fun of me, my colleagues make fun of me for emphasizing the importance of naming conventions. That just makes everything easier and everything easier to find. So I'm sure I'm not the only person who believes strongly in the value of naming conventions. So the best practices for motions and resolutions is to record them verbatim and to read them back to make sure you get them right, and to make sure before taking the minutes that the conditions are clear and accurate. That is very important to document because it is your tool, your key to enforcement are those conditions, and that they are clearly written and summarized. And the minutes should be available to the public and distributed before the next meeting. You can make available a draft copy of the minutes if you approve them. And obviously the value of approving them is that any necessary corrections and inaccuracies, corrections to inaccuracies will be made, and potentially additions too. So the discussion summary in your minutes should include the key points of discussion, separate facts from separate facts from opinion, so that you're really making clear what happened, what is the case, what the land, what the constraints on the property are that's being considered, versus what a neighbor thinks will happen if it's developed in a certain way, for example, or what the developer thinks that it's going to be great for the neighborhood, that's a personal view, and those should be separated in quotes and so forth and attributed to the speaker. And even if there are, even if there is inappropriate or colorful language, that should probably be kept out of the minutes. And subjective interpretations. I was corrected once when I took the minutes for the planning board that I staffed. There was an angry applicant who I described as storming out of the room, and my director softened that, corrected it, made it less subjective, and I always think of it when I present this slide, and that was the right thing to do. So, and obviously items not discussed should not be included in the discussion summary of the minutes, and obviously not the typos. They should be reviewed sometimes by, there's a second set of eyes is always a great thing. And approval, again, is common but not required. And you might have something in your rules of procedure that lay out those rules, whether you're going to approve them or not, whether minutes shall be approved. If you are approving, the initial draft should be marked as draft, and it can be made available. The draft should be available to the public within 2 weeks, and if decisions, and this is not recommended, to make decisions in executive session, but if they are, then you have to take minutes, and those have to be available even sooner. And tape or video is optional, but it's subject to retention for several months. And if you keep it longer and somebody asks for it, somebody foils the recording, and it's not required that you keep it, I don't know off the top of my head, I think it's a number of months, but if it's a year later and you still have the recording and somebody foils it and you have it, you have to share it according to the law. So James is going to wrap up with archives retention, and then we'll take some questions.
Okay, thank you, Chris. We're going to talk about archives and retention. Again, it's really good, it's very important to have a system where you can retrieve information, having a filing system so that someone off the street, if they were to come in, it's comprehensive, clear, so the documents can be found, all your documents, your file folders can be found. Often, cities and villages with, built out, they'll reference projects by address. However, sometimes addresses change, particularly in rural areas, so it's helpful to cross-reference by section, block, and lot number. Why this is important, variances run with the land, not with the landowner and applicant, so the SPL can really make sure it's an easy way to track a parcel history to keep that variance with the appropriate parcel. Why use an SPL? An SPL is a unique and permanent identifier. It's assigned to a specific parcel. It is the only one in the state that has that number. Again, physical addresses may change, but your SPL number is consistent. It gives precision for vacant and complex properties, particularly properties that might not have an address or the address is ambiguous. The SPL is directly linked with the tax map and assessment roll, so it's easy to verify ownership. SPL tracks subdivision and lot line adjustments. When properties are subdivided or amalgamated, a new SPL is created, an additional number is just added to that SPL, so you can track where that property has gone. And most importantly, it provides legal clarity. Resolutions, conditions of approval that reference SPL numbers create a clear and unambiguous legal record for that decision. Finding records related to a current application. How can you check for previous granted variances? Again, cross-reference the planning board ZBA decision and building files. Even if it's in the minutes, information about approvals should be in the property building file. Archiving, your records management officer, that is your municipal clerk. and your board secretary or municipal planner usually maintains your planning board and ZBA minutes. The clerk, they're going to maintain custody and curate all archived records, including a set of minutes of all meetings. And state archives records retention schedule. You need to permanently archive official meetings, hearing proceedings, and project files. The exception for project files are single-family home variances. Those are kept for 25 years. Temporarily retained voice recordings for at least 4 months after transcription or approval of minutes, and handwritten meeting notes until drafted or transcribed. So I think, Chris, we're ready for questions.
Okay, and there it is. It's 4 months. I was thinking off the top of my head 3. I should have just turned a couple pages further, and I would have seen this. The easy thing to remember here is minutes and project files. You pretty much have to keep them forever. So I know we always go through. We have this slide in a couple of our courses. So yeah, why don't you advance to the next one, James, so that we can remind everybody, and most of our group stayed with us, so thank you. Sorry, we got a few minutes behind. Please be patient with your certificates, and we will, there is a recording of the training, and the certificates will include them. And we'll leave this slide up so that you have our phone number and web address and email address. But let's talk about a few of the, let's go over a couple questions. I think we can spend another 10 or 15 minutes, and then anybody who stays on, we'll have 2 hours, I guess.
I have one ready for you if you're ready to go.
Great. Thank you.
So can you go back over the procedural process for public hearings versus public meetings in terms of noticing them?
For the paper,
for the paper and time frame and all of those.
Yeah, I'll scroll back in the course, and I think one of the distinctions is that the distinction is the really important part. Meetings are regular convenings, and hearings are for the public to comment. The meeting notice requirements are here. Provide a date and time to the media at least 1 week in advance, and if it's a special meeting, notice at least as soon as possible, at the earliest time you can, and so the notice to the media, the time and date to the media 1 week in advance. That could be at the beginning of the year. You send your schedule of regular meetings to the reporter who covers your meeting. I did this as a municipal planner, and in January or in December of the previous year, I would just send the regular meetings to the media. This is not the legal notice. That's different. That's for hearings. And then post at least 72 hours in advance. But if you post that regular meeting, that schedule of regular meetings, you're satisfying that, but then you should post the agenda. There's the more information that's out there. There's the difference between complying with the spirit of open meetings, complying with the letter of the law and the spirit of the law. And if you go over and above, you're really trying to get the word out, you're really working in the spirit. You might be going over and above the letter of the law. On the municipal website, and then of course, if you're video conferencing, the meeting locations, if they're public, and if there's a streaming option, the URL where members of the public can log in. And the distinction between that, maybe it was hard. I noticed in most of our courses, the hearing notice requirements come right after the meeting notice requirements. It's the same as the meeting notice requirement plus the legal notice. That's really the distinction. So I hope that answers the question, and we'll take a few more. Lindsay, Monica, do you have?
Yes, could you also, I know we asked you this one, but we've still gotten several more questions regarding if someone is remote and video conferencing into the meeting, can you go over the whole, like, how that needs to be posted publicly prior to the meeting and local law, et cetera? Because we've been trying to reiterate that, but not everyone's seen it, I don't think.
Okay. Well, I just cleverly went to the end, and we'll scroll back to that slide. I should have the, let's see, where is it? It's a few slides back from here, I think. There it is. So, okay, to have members participate from non-public locations, the first thing you have to do is get your local governing board to adopt the extraordinary circumstances provision. And you can find more information about this in our publication, Conducting Public Meetings and Public Hearings. We have information, we go into a little more specific detail in that publication. You can read it over and over. You can read it and really focus on it. Sometimes I have to read a law and some confusing language 3 times before it really sinks in. So you can read that. And the Committee on Open Government has more information on it. So we can send you that if you're really interested in doing it. But so the adoption of the extraordinary circumstances provision, and then you must, the board has to say that if you're not streaming the meeting, if you happen not to be streaming the meeting, that board member will be on screen and audible at the public meeting, at the public location. So members of the public will be able, you can't just call in on a conference call. It has to be teleconference. So the members of the public should be able to see and hear the member who's participating from a non-public location. And a quorum is required at the public location. So you can't do it in the event of a snowstorm or something like that. It has to be in extraordinary circumstances, as you can see, is not defined by the state. That's up to your local governing board to define. And we'll tell you there are not many local governments that do this. So I think many think, oh, we can meet totally remotely. No, that's not the case. There still has to be, I think the hitch is that a quorum has to be in the public location. Next one, and I can start reading a few of these, but I'm sure you have some.
Oh, I have another one for you.
Okay.
Similar vein, but slightly different. Can a video or audio recording be used as the meeting minutes?
It could be, but that's not ideal. It's harder to, like, if you want to find fast information, you don't want to watch the entire recording. But I think it's technically allowed, not advisable though.
Chris, wouldn't you want to have that transcribed, because an audio or visual, that could get damaged over time and get lost?
Right. That's a good point. And are verbatim transcripts required for hybrid board meetings? That one, I'm not sure of that one. There was a slide, and it kind of surprised me to see this information, because when boards, with the suspension of in-person meetings, there was the requirement for transcripts. I'm going to have to double check on that one. for the extraordinary circumstances provision. If I had to guess, and maybe somebody can look that up while we're working on this and check the law, Section 103A in Open Meetings Law, while we're talking, I'm thinking that it might be, because remember I comment. There's a lot of work involved in having a member participate remotely. But I am not certain of that one. So, I'm just looking at some of the questions here. Anything else that stuck with you, Lindsay or Monica, or James for that matter? Are there any other questions that you feel that we should pay some attention to here?
Sorry, we're trying to filter through all the questions that have quite a few.
Go ahead.
But if you see one that jumps out to you that we clearly haven't answered.
Yeah, well, it looks like there are a bunch that you have answered. You did a great job of this.
Can you just reiterate for executive session that if something is legally pending, pending would have to be correct that that there's actually an action, not because somebody has threatened legal action to go into executive session, correct?
Yes. There are reasons for 8 reasons to go into executive session. We don't have them listed in this course. They are in our public meetings and hearings course and in the publication, the James A. Kuhn Technical Series publication, Conducting Public Meetings and Public Hearings. There are 8 reasons, and planning boards and zoning boards of appeals should almost never have to go into executive session. They're mostly for reasons that wouldn't even come up for planning boards and zoning boards of appeals. I think there might be 2 or 3 that could possibly come up. History of a person. So if the planning board or ZBA is considering hiring a planner or a clerk or secretary or some kind of staff member, then they might be discussing history of a person, and they could go into executive session to have a discussion about somebody's background, that person's background. So it's relevant to this discussion. Other reasons for going into executive session, and the distinction between executive session and attorney-client privilege is the board can meet with their attorney to discuss legal matters as a less than a quorum or a full quorum, and that's attorney-client privilege, like outside of an open meeting. But in executive session is often called during a public meeting where the board feels it has to go into executive session for one of the 8 reasons. They go into executive session, they have their discussion, and then they come out of executive session and go back to the open meeting. And one of the other reasons planning boards and zoning boards of appeals might have some reason to go into executive session is actual litigation. When there is an ongoing lawsuit on a certain matter that the board shouldn't be discussing in public. If it's about actual litigation, they can go into executive session. But if somebody's threatening to sue the board, no, that's not a reason to go into executive session. Thanks for that, Monica.
Chris, wouldn't you recommend in most cases that to resist the urge to go into executive session? I know sometimes board members, they might want to do it because they'll talk about something that might be controversial, but nevertheless, those conversations, those deliberations, discussions need to be in public, right?
Yes, so well said. There's an urge to go into executive session when you want to talk about something that's not going to be popular with some of the people in the audience, but it's not a legitimate reason to go in. That's what open meetings law is all about. The deliberation of your public boards has to be in public. So yes, there is that human urge to go to not to say things that are unpopular, not in front of the people who are going to be angry at you. But there are not many reasons that the reasons, the legitimate reasons for going to into executive session are very few.
Okay, I have another question for you.
Okay.
Do you need to have a paper project file if your town has gone digital?
I don't think so. I don't think that's required anywhere, and it might be something that would be good to have as a backup, but I don't think it's necessarily required. And we could check with our colleagues at we have a counterpart, a local government division counterpart at state records, at the state archives, the New York State Archives. And we could ask that question of them. If the person who asked that question wants to email us, I think that's what you should do. If you're really interested in the answer of whether you can go totally paperless, my inclination is yes, but I'm not gonna say that with absolute certainty. But if you have most of your records online and you don't want to have paper copies, that I'm nearly certain that is fine, but we can double check that. Send us an email and we'll double check it with our colleagues at State Archives. Anything else?
I have one other one for you. I don't know how much longer you want to keep going, but I will ask this one and then we can always pause. So, can the code officer and/or planning and zoning board clerk decide on whether an action is type 1 or 2 before it goes to the planning or zoning board?
That's a really good question.
It's a great question.
I think if it's, there's no clear, I certainly don't know of any case law that gets into this, and I don't think there's any real statutory or statutory guidance in either seeker or anywhere else, but that's what the lists are for, and that's why we encourage staff to be familiar with them. I think that if it's, I've been involved with boards, and the short EAF was a part of every application, and sometimes it's valuable to get that information. But if every application is clearly type 2, and applicants are filling out the EAF and they think they're going to have to go through the seeker process, there could be the advantage, and some boards just kind of include the EAF as a matter of course, and it's even recommended by some. But to have the option of, clearly it's a type 2 action, you don't want to include the EAF, it's something that you could choose not to. And if somebody's clearly seeing that it's a type 2 action beforehand, before the board even considers it, I think that's just going to streamline review. And the seeker process, that it isn't a factor in certain applications. I think that it's probably a good thing for staff to maybe have, and I think there are a lot of professional planners that do this. They will look at the applications and they'll look at, for seeker, they will classify the action for the board and have a staff report for the board. So there's no reason that the enforcement official and or other staff to the board can't do that too. Can't say, hey, we're looking at the type 2 list and we're not seeing this on there. It's probably unlisted because it's not on the type 1 list either. And the board can look at it too and say and disagree. So there's no reason really why the staff shouldn't make that initial classification and have that, put that forward with the application to the board. As long as the board has the information to potentially dispute it if that's the case. So if there's something else pressing that the two of you see, we can take one more, but if not, then maybe we'll wrap up. I figured if we go a little late, then some people will get a little more time, those who could stick around. Okay.
Sorry, Chris.
No, not at all.
I have one more that might be useful to the whole audience. Someone is asking if a board goes into executive session, are those FOILable notes?
They are if they make a decision in executive session. And so it's, going into executive session, you're not really supposed to vote. The reason for going into executive session is to keep sensitive information out from discussion, and then to reconvene in the open meeting and make the decision then, and then take the minutes. But if decisions are made in executive session, you have to have minutes, and that kind of defeats the purpose of going into executive session. So, yeah, interesting question there that you could probably get a little more from our colleagues at the Committee on Open Government, but that's my understanding of that situation.
Thank you. I think that is really it for us, although I did maybe just see another one come in. Hang on, let me. Oh, yeah, someone's asking if the meeting is over. So I think we are all set if you both are good.
I think so. Thank you for the many people who stayed on extra time, and it seems like there were a few who needed 2 hours credit. I think we're good for that at this point. So we hope those people who say they need the 2 hours credit will come and join us. We'll see you in person in the near future. So thank you everybody for your participation. Your certificates will be coming in probably early next week, and call or email us if you have any other questions. Thank you again for being on the webinar and for your service to your municipality. Thank you, James and Monica and Lindsay and John.
Thank you. Bye, everybody.
Bye.